Hello everyone. Today in the subject of industrial biotechnology, we are going to study about patent law. So in this lecture, you'll be able to understand that what is the main patent law in India and what is the meaning of patent law, and outcome will be that you'll be able to understand what are its fundamental applications and necessities in current era or current scenario of industrial biotechnology. So, coming on to the patent. A patent is a type of intellectual property that gives its owner the legal right to exclude others from making, using, or selling an invention for a limited period of years in exchange for publishing and enabling public disclosure for invention. So, it is patent is a type of intellectual property right, right? And it gives the owner that particular right that he can control the using and selling or uh, his or her invention for the particular period of time. So this scenario is very much useful, and the product that has been designed by you or the design is specially exclusively created by you, then you have the right uh, to use it, and others cannot exploit it or use it or copy it. In most countries, patent right falls under private law, and the patent holder must sue someone infringing the patent in order to enforce his or her rights. So, in most countries, patent rights falls under the private law. So, if anyone is using your things without any information or without giving you the privileges and rights, taking rights from you, and infringing the patent, then you can sue them under the law. In some countries, patents are an essential form of competitive advantage. In others, they are irrelevant. So, in most of the developed countries, this law is extremely uh, useful because most of the things come under this law. But in other countries, it has no relevance. So, this create a very indifferent situation for the people who are working hard to create something, and it is being copied in some other countries and being used as such. So, this law is somewhat uh, related to intellectual property rights, and sometimes it is applicable in some countries. They follow the protocols essentially, but sometimes in other countries it does not follow them, and it is totally irrelevant in nature. The procedure for granting patents requirement placed on the patentee and the extent of the exclusive rights vary widely between countries according to national laws and international agreements. Right. So the procedure for granting patents requirements placed on patentee. So it depends totally on patentee. What are the things that you are getting patented? Okay, what are your requirements? And the extent for the exclusive right vary widely between countries according to national laws and international agreements. So, patent law is mostly influenced by the international agreements and the way the things proceed in addition to the scenario. So, most probably, the patent laws are influenced, sometimes they are influenced from the regulations that are being practiced by other countries also, but sometimes they are exclusively to the according to the national laws also. So, the scenario also varies in nature. Typically, however, a patent application must include one or more claims that define the scope of protection that is being sought. So, a patent application must include all the documents and all the claims that define the scope of protection that is being sought. A patent may include many claims, each of which defines a specific property right. Right. So, it can have many claims, each of which defines specific property rights. So, what are the things that are responsible for doing anything that is exclusively designed by an individual? Right. It is very much significantly uh, the person related to the person who designed that very blueprint. So, if you want to use it, take the permission or give him the privileges that he demands, the amount of money he or she needs. So, all these things come under the patent law. These claims must meet various patentability requirements, which in the US include novelty, usefulness, and non-obviousness. So, all these things comes under the umbrella of patents. Definition. Now, coming on to the definition. The word patent originates from Latin patere, which means to lay open. That is, to make available for public inspection. It is a shortened version of the term letters patent, which was an open document or instrument issued by a monarch or government granting exclusive rights to a person predating the modern patent system. So it system of patent is very old, and earlier it used to be an open document, and the monarch or the government used to provide that person some rights according to his or her invention. Similar grants include land patents, uh, which were uh, which were land grants by early state governments in the US, and printing patents, a precursor of modern copyright. So, from time to time, things have been changing, and it has seen a lot of change in the significant past. In modern usage, the term patent usually refers uh, to the right granted to anyone whom who invents something new, useful, and non-obvious. A patent is often referred to as a form of intellectual property right, an expression which is also used to refer to trademarks and copyrights, and which has propagated and detractors. So, this has all been done under the intellectual property rights scenario, right? So, one person controls the all the rights and all the novelty related to an invention or related to a new idea. So, he or she get the things patented, and if anyone who is interested in that very particular invention and want to use it, then he has to take rights from that owner, providing him her the novelty in return. Some other types of intellectual property rights are also called as patents in some jurisdictions. Industrial design rights are called design patents in the US. Plant breeders' rights are sometimes called plant patents, and utility models. And G. are sometimes called patents and innovation patents. Introductions. The Patent Act 1970, along with the Patent Rules 1972, came into force on 20th April 1972, replacing the Indian Patents and Design Act 1911. The Patent Act was largely based on the recommendations of The uh, Nagar Committee, reported head by Justice N. Gopala Nagar. One of the recommendations for the allowance of only processed patents with regards to inventions relating to drugs, medicines, food, and chemicals. Later, India became signatory to many international arrangements with an objective of strengthening its patent law and coming in league with the modern world. One of the significant steps towards achieving this objective was becoming the member of trade-related intellectual property rights system. Significantly, India has also become signatory of the Paris Convention and Patent Cooperation Treaty on 7th December 1998, and thereafter signed the Budapest Treaty on 17 December 2001. So, following all these changes, India has to make a lot of significant uh, scenario change in its own rules and regulations, and also regarding to the laws of patents and intellectual property rights. So, India made several amendments in its own rules and laws regarding to the patent system that it was following in the early days. And most of the laws were very old and they needed some sort of amendment also. They were as old as since 1911, and uh, they were modified during 1970s. And since then, the Rajgopala committee reported that these and suggested many changes. Right. So, following those changes since December 1998 to 2001, there have been various treaties have been signed by India that also required many changes in their laws and regulations for the opening of international market. History. Being a signatory of TRIPS, India was under a contractual obligation to amend its Patents Act to comply with its provisions. India had to meet the first set of requirements on 1st January 1995 to give a pipeline protection till the country starts granting product patents. On 26 March 1999, Patents Amendment Act 1999 came into force retrospective effect from 1st January 1995. The main amendments uh, are as follows. Section 5 of 2 was introduced, which provides for filing the applications for patent in the field of drugs, medicines, and agrochemicals. These applications were kept pending in the mailbox or black box. This mailbox was to be opened on 1st January 2005. So here you can see types of patents. We have utility patent, design patent, plant patent, reissue patent, and then the patent is renewed. So utility patent depends on uh, invention of any of machinery or the thing or a device that can be really very utilitarian for the individuals. Okay, design patents, right? Something has been engineered or the circuit diagram that has been totally new innovation. So it should be design patent. Plant patent includes any plant that has been significantly new to the market or it has been genetically modified plant breed. Reissue of the patent when patent lapse after following a fixed duration of time. Then it is reissued in several cases, completing the whole scenario. These are the types of patents, and Uh, when India became international member of TRIPS, it has to go through under several of the changes and amendments. So, following that, since 1st January 1995, it started to give a pipeline protection till the country starts granting patents. Till 26 March 1999, Patents Amendment Act 1999 came into force, retrospective of effect from 1st January 1995. So everything suddenly changed, and while India was becoming more and more aware of its international scenarios, and several attempts were made to upgrade its laws and the concept that were being followed in order to enhance and upgrade its system and laws according to the developed countries. So it not only opens the market, but it also opens a new dimension for the development and opens a new market for the competition of the people who are working on in this context on this area. Provisions of exclusive marketing rights (EMR). So exclusive marketing rights is also a new thing was bought in the way of Chapter 4A. Thus, pipeline protection was provided for pharmaceutical and agrochemical manufacturers whose application for product were lying in black box. So, what they have to see that pipeline protection was very much crucial for pharmaceutical and agrochemical manufacturers because they all have to follow a very long scenario of testing and making the things usable and reliable. And following that scenario, following that chain, they have to make sure every time the things are up to the mark, and every time the things that are being designed or the things that they are making or the chemical products that they are trying to manufacture, everything should be up to the mark and everything should be new, right? Most of the time when it comes to the pharmaceuticals, that very particular chemical component or the drug component that they are designing, it should be based on uh, the formulation that has been properly tested on the cell lines, and after that completing the whole scenario, that very particular drug or chemical has to be tested on small animals, then following the rules, okay, or following all the biosafety rules, then it is it runs its trials and testing on human source. So following this scenario, the product that is obtained is extremely up to the mark and it should be patented, but it should cover all the scenarios and all the reasoning that is essentially required for uh, the patenting procedure. It should be safe in every sense, and it should not have any sort of ill effects or the effects that are not known till date. So that is why when it comes to pharmaceuticals and agrochemicals manufacturers, the patenting or granting patent or legal rights takes a lot of time for the reason that these products they do have a different scenario to them, linked to them, right? They are mostly involved with the living systems or different type of organisms or different types of plants. So if they are going to have any of side effects or any of the effects that is not yet known to the scientists, then it can create a big issue. So most of the time, for taking patents for the drugs or taking permission for their manufacturing does require a lot of time and effort. So it is extremely important you understand the pros and cons of taking any patent while it comes under the uh, umbrella of pharmaceuticals and agrochemical uh, classification. Section 39 was omitted from the Act, thereby enabling the Indian residents to file the application uh, in and outside India simultaneously. So, earlier, what people used to do, if they are not granted patent in India, they will go and file their patent somewhere else outside the country. So this section was deleted, and in order to file patent somewhere else, first we have to file the patent in India. Chapter second A was inserted in the Indian patent rules dealing with international applications under PCT. Now, because of the amendments, any international candidate can also apply for the patent in India. So, as the scenario was changing, India was becoming more and more aware of the scenarios that were being followed internationally and that were extremely important when it comes to patenting provisions. So here you can see what are the important aspects: intellectual property, copyrights, patents, inventions, trademarks. Everything is interlinked and connected together. So if you want to make a progress, you must understand the scenarios that are essentially required. The second phase of amendment was brought in by the Patent Amendment Act 2002, which came into force on 20th May 2003. The main features of the amendments include. So, see, India is always upgrading its amendment acts or patents that are being constantly upgraded or receiving amendments. So, whenever there is a change in the scenario, whenever there is a change in the uh, rule internationally, India has also uh, observed the things and the things that are of great utility or logical significance. It has been made significantly reliable, and the changes were introduced from time to time. So, what are the main features that were included in the amendment? First, term of patent extended from 14 to 20 years, wherein date of the patent was the date of filling the complete specification. Also, the difference in the term of a drug, food patent, and other patent was removed. So the main thing is that term of patent was extended from the time period of 14 to 20 years, right? So earlier it was a very short duration of time, and it went on, right? From from the very early beginning, the time period was extended from 14 to 20 years, right? So, in the starting of the scenario, when it started in India, the time period of obtaining a patent was only 14 years. For the time period of 14 years, it would be exclusive for the individual who is signing the patent. But when it comes to signing of other system, the 20 years was upgraded. It was upgraded to the 20 years time period, wherein the date of and they considered the date of signing that very particular patent to the scenario uh, when the individual is going to fill the details of specifications and trying to file the patent. Also, the difference in the term of a drug, food patent, and other patents was removed. So, uh, this significant classification was removed. A drug or food patent and other patents were removed. So every patent was a patent, whether it's a machinery or mobile phone or anything, right? A patent is a patent. The classification was further removed. The definition of invention was made in conformity with the provisions of TRIPS agreement, introducing the concept of inventive steps, thereby enlarging the scope of invention. Right. So the definition of invention was made in conformity with provisions, and several agreements were made and introducing the concept of inventive steps, thereby enlarging the scope of invention. So it also broadens the term of invention, and now more and more people can very easily apply for the uh, patents. Third, deferred examination system was introduced. Everything was thoroughly checked. Everything was now checked according to the details of the scenario. Right? Earlier, it was not possible, and following all these terminologies and following all those essential items were not earlier possible. So, filing the patent nowadays requires a good amount of time, and one, the patent is thoroughly observed and thoroughly checked, and deferred examination system is proving to be successful. Introduction of the previous uh, of publication after 18 months from the date of filing, thereby bringing India at par with the rest of the world. So you can publish your patent after 18 months of filing, and India was very much up to the mark after those amendments till the date of 20th May 2003, and every thing is according to the scenario that is being followed internationally. So because of that, India came step by step with other developed countries who are running the similar laws and scenarios. So types of utility patents. And provisional application. This application is usually for the companies want curb down the production cost during the company's initial. Okay, so this is provisional application. Direct field application. It is the foremost and the first filed application of an invention. This is direct file applications and provisional applications. Divisional applications, if you are pursuing two different inventions and filed a utility patent applications for both inventions, then you need to utilize division utility patent applications. So there are different types of utility patents for different types of applications, and as a result of those things everything is followed significantly, and everything is done in a very significant manner. Microorganisms became patentable, whereas inventions relating to traditional knowledge were included in the list of what are not inventions. So, microorganisms were also included in the patentable items list, and the whole uh, list or the whole protocol was invented what are not inventions in order to solve the this debate and the issue that it was creating. The concept of unity of invention in accordance with EPC and PCT. The Section 39 was reintroduced, thereby prohibiting the Indian residents to apply abroad without prior permission or first filing in India. So, because of Section 39, uh, if you are filing for patent outside the India, right, then you first have to file for permission uh, to be taken from India. Then you are allowed to file for the patent outside India, and without that you cannot file patent outside the country. So with the amendment this was made inevitable by the committee, so that things should be properly remain as they are, and everything should be in knowledge of the committee that is running the patent committee in India. Provision of appellate board were brought uh, in by insertion section 116. All appeals to the decisions of the controller would be appealable before the appellate board. The headquarters of appellate board is to be in Chennai. So, appellate board has been significantly found due to the insertion of section 116, and decisions of controller would be appealable before the appellate board, and its headquarters are in Chennai. And if you have any issues, you can file an appeal at appellate board in Chennai. Section 117 provide for bowler provision for the benefit of the agrochemical and pharmaceutical industry. Right. So Section 117 provided for bowler provisions for the benefit of agrochemical and pharmaceutical industry. So they also made significant changes when it came to the factors involving pharmaceuticals and agrochemical industries. So patentability criteria. So inventions, they should be uh, unobvious, novel, useful, and statutory. So they should be totally new ideas, and it should be extremely useful, and nobody should have thought about it, or nobody is currently working about it in statutory, and it is extremely new to the uh, crowd, or new to the people. So these things are related extremely with the uh, invention, and if you have all such factors inculcated in your invention or the patent, then you are most probably to get the patent in your name. The third and final amendment of Patents Act 1970 came by the way Patents Amendment Ordinance 2004, which was later replaced by the Patent Amendment Act 2005 and Patents Amendment Rules 2006 with retrospective effects from 1st January 2005. With the Third Amendment, India met with international obligations under TRIPS. Significant achievements of this amendment were deletion of Section 5, opening of mailbox and grant the product patents. Thus, this amendment led to the draw of the product patent regime in India. So it also stopped some practices that were earlier done, and made many changes. Uh, uh, abolition Abolition of exclusive marketing rights (EMR). So marketing rights were not at all exclusive now, and anyone can get the access to it. Current position: the present Indian position uh, in respect to the patent law is governed by the position of Patent Act 1970, right? So, as amended by the Patents Amendment Act 2005, hereinafter referred to as the Act, and Patent Acts Rule 2006, hereinafter referred to as the rules. So every time things are changing, and every time the scenario is uh, changing. The head patent office is located in Kolkata, and all the activities are being carried out because of these things. And its branch offices are located at Delhi, Mumbai, Chennai, and patent system in India is administered by Controller General of Patents, Designs, trademark and geographical indications. Each office has its own territorial jurisdiction, for receiving patent applications and is empowered to deal with all sections of Patent Act. The jurisdiction for filing the patent application depends upon Indian applicant, determined according to the place of residence, place of business of the applicant, and where the invention actually originated. For an applicant, determined by address of for service in India. So, what is the main purpose of patent law as we are discussing? The basic aim of patent law is the balance of interest of inventors. On one hand, uh, the interest of the public. On the other hand, right, everything should be balanced. It should not be in one hand. Right, the inventors are rewarded with a limited exclusive right on their invention. So it is not like that all the rights are taken from the inventors. Inventors are also given some right according to the law for providing technical progress to the public. The exclusive right is limited in time, that is maximum 20 years, in territory for the country in granting the patent, and its context on the patent invention. Patent protect the investments made for research and development and create an incentive for innovation. So it is also very beneficial for the individual who has done the innovation. Granted patents as well as patent applications are published. They therefore provide an insight into current technological developments and help avoiding parallel redundant developments. So when the patent is done, everything is exclusive according to the laws, and patent protection is granted to the inventor. So nobody else can readily copy his or her invention. Patent protection is not only relevant for natural persons or and enterprises, also public institutions make use of patent law, right? So it is universal. Nowadays, every country is having these laws and enforcing them everywhere. So in the long term, everything is very much transparent, and everything has been made easy for the people who want to see these things and who want to listen more and more to these things, right? So patent system is a contract between inventor and authority, whereby inventor gets exclusive rights for the period of 20 years, and in return disclosing full details of invention. The main purpose of the patent system is to encourage innovation and eventually result in technical development. So, in the long term, most probably what we see here is that when the patent rights is granted to the innovator for the time period of 20 years, he or she is having the full rights to be secured, and she does not have to disclose anything to anyone for the time period of 20 years. So the main purpose of the patent system is to encourage innovation and eventually result in some sort of technical developments. So what are innovations? The Act provides for the definition of the invention, which is now complete with provisions and TRIPS. The criteria for patentability of an invention are novelty, inventive steps, and industrial applicability. Section 2 of 1J of the Patent Act 2005 defines the invention as a new product or process of involving an inventive steps and capable of industrial application. So anything that is totally new and totally uh, indifferent to the current scenario, and the main process it involves is uh, inventive steps. Everything is upgrading upgraded, and idea is totally new. Under the Act, new invention is defined under Section 2 of 1I of the Patent Act. New invention means any invention or technology which has not been anticipated by publication in any document or used in the country, elsewhere in the world, before the dates of filing the patent application with complete specification. That is, the subject matter has not fallen in public domain, or that it does not form part of the state of art. So everything is totally new to the inventor, and nobody else is aware of it. So in the current scenario, it means that everything is has been totally limited to the inventor, and that is why he or she wants to achieve patent, because it should not be used by anyone else. So filing the patents also includes that most of the time the things are very much essential. Okay, and things are extremely exclusive to the individual who is filing the patent, and nobody is currently aware of it. Okay, about his or her invention, and things have not been yet fallen into the public domain. Thus, according to this definition of new invention, Act talks of absolute novelty. Everything is totally new. That is, the invention should have neither been used anywhere in the world nor published in any part of the world. So, invention should be totally new to the context. However, the later sections of the Act, for the purpose of anticipation and opposition proceedings, deals with the relatively novelty that is not used in India and not published in any part of the world. So, uh, for filing the patent, your work should be totally novel, and it should not have been used by any of the uh, individual in any part of the world. Right. Further, entire act refers to the word invention and not new invention. Therefore, for all purposes, relative novelty is the creation. Exceptions to the novelty rules. So, although you might have understood the novelty rule that has been implemented and followed many of the amendment acts, but what are the exception to this case? Not all everything is being followed according to the scenario. There are few exceptions to the rules of novelty is not applicable. The cases are as follows. So, what are the things that have been excluded under the rule of novelty? Subject matter published without the consent of inventor. Okay, if subject matter is has been published without the consent of inventor, then it is not a novelty thing or not a new thing. Okay, it is not applicable. The invention was published in consequence of the display in an exhibition notified by the government or reading the paper before the learned society. Then it is not a novel thing. It has been already fallen into the public domain. Grace period of 12 months is given in such cases to file the patent application. So, if such scenario is being presented or such scenario is being faced by the individuals, then grace period of 12 months is given in order to make the changes. Previous communication to Government of India, public working for reasonable trials. So, all these things are included in the terms that are not novel. Inventive steps is defined under Section 2 of 1 JA of the Act. Prior to the amendment of 2005, inventive steps meant a feature that makes the invention not obvious to a person skilled in the art. The new Act of 2005 defined inventive steps more precisely. Inventive steps means a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance for both, and that makes the invention not obvious to a person skilled in the art. Thus, in addition to the non-obviousness criterion, two other conditions were added. That is, it should also involve technical advancement as compared to existing knowledge or having economic significance, or both in addition to being non-obvious. The term technical advance and economic significance have not been defined clearly and are unambiguous. It cannot be left to presumption. Economic significance is synonymous to the phrase capable of industrial application in section 2 of 1 AC or in footnote of 5 to article 27. The meaning of the phrase technical advanced cannot be presumed either in absence of a specific definition or reference. The Patents Act 1970 had a very limited scope for protection, wherein the essential elements of invention were new, useful, and manner of manufacture. Even though manufacture was not defined in the old Act, the Patent Office established the practice of interpreting manufacture as a process resulting in tangible product. The landmark decision in Calcutta High Court on the process of production of Bristis virus containing vaccine, uh, Domenico AG versus Controlled Patents of 2002 changed the practice, and now the definition of invention is interpreted keeping in mind the term industrial applications under Section 2 of 1J. So the Act defines capable of industrial application in relation to the to an invention as capable of being made or used in an industry. An invention is capable of industrial application if it satisfies the three conditions culminatively: can be made, can be used in at least one of the field activity, can be reproduced with the same characteristics if may necessary. So this is the patent cycle. First is invention disclosure prior to art of search. Third is patent filing. Fourth is patent prosecution. Uh, Fifth is patent enforcement. So what are not inventions? Uh, Inventions, Section 3 of the Act deals with non-patentable inventions, inventions which are frivolous or contrary to well-established natural laws. For example, inventions relating to perpetual motion alleged to be giving output without any input uh, is not patentable as it is contrary to natural law. Merely making in one piece article previously made in two or more pieces is frivolous. Mere usefulness is not sufficient. Okay. So, what is the benefits of Indian patent search? Assist receiving a royalty, help in selling or licensing the patent right, offers global recognition, increase brand image and goodwill, results in rising capital, provides monopoly advantage. Invention whose primary or intended use or commercial exploitation could be contrary to public order or morality, or which causes serious prejudice to human, animals, and plant life, or health, or to the environment. For example, terminated technology which involves inserting a gene sequence in a seed to stop germination or growing recombinant plants, leading to disappearance of butterflies. The mere discovery of this scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substance occurring in nature. However, isolation of living thing or non-living substance is patentable as it involves human technical interventions. Merely near discovery of a new form of a known substance, which does not result in enhancement of the known efficacy of that substance, or mere discovery of any new property, or new use of a substance, or mere use of known process, machine, or apparatus, unless such known process results in a new product, or employ at least one reactant. Explanation of Section 3D. Salt esters, uh, ethers, polymorphs, metabolites, pure form or particle size, isomers, mixtures or isomers, complexes, combinations, and other derivatives of known substances shall be considered to be the same substances unless they differ significantly in their properties with regard to efficacy. So, efficacy has been also been really discussed with synergism of patentability, and pharmaceutical products have been also going through a lot of change. So, procedural act, who can file the patent application? An application for a patent for an invention can be made by any of the following person, either alone or jointly with another. True and first inventor, his or her legal assignee, legal representative of deceased inventor or assignee. Foreign filing license. No person resident in India shall, except under the authority of a written permit, can file any application outside India for the grant of the patent unless an application for a patent for the same invention has been made in India not less than 6 weeks before the application is filed outside India, and either no necessary direction has been given under Section 35A, 35(1) in relation to the application in India, or all such directions have been revoked. A request for filing license may be filled on prescribed form with detailed description of the invention and the drawing, if any, of the prescribed fee. These are the MCQs. Patent application can be filled in India by uh, a true and first inventor, assignee of the inventor, legal representative of the inventor, all the above. The correct answer is all the above. Patent application contains Form 1, Form 2, both A and B. The correct answer is both A and B. Complete specification contains title of invention, description of invention, claim, or all the above. The correct answer is all the above. If you file provisional specification, the complete specification is required to be filed within 10 months, 12 months, 18 months, or 24 months. The correct answer is 12 months. Indian patent system has pre-granted opposition, post-granted opposition, both A and B. The correct answer is both A and B. Pre-granted opposition can be filed by any person interested, both A and B. The correct answer is any person interested. Patent can be revoked in India, yes or no? Yes, in some cases. Working of the patent is required. Uh, Working of patent is required in India. Yes, it is always required. Patent of addition can be filed by inventor, patentee, both A and B. Both A and B. Patent can be infringed by directly, indirectly, both directly and indirectly. These are the references from where we have collected the material. Thank you very much for listening to my lecture.